Hi, my name is Madison Miller, and I did my report on controlling speech in the book A Gift of Fire, Social, Legal, and Ethical Issues for Computing Technology. This is in the 4th edition, chapters 3.2, on pages 134 through 152. So here's a brief objective of the chapter. So we'll first be talking about offensive speech and why it is illegal, the laws and regulations used to filter the use of offensive materials on the web, the risk of violent video games, alternatives to censorship, the definition and restrictions of child pornography and sexting, cases and restrictions of spamming, and challenges of old regulatory structures. So 3.2.1 is on offensive speech. What is it and what is illegal? So what is offensive speech and what the law should prohibit on the web? Well, some will argue that the answers depends on who you are. Offensive speech could be political or religious speech, pornography, racial or sexual slurs, Nazi materials, libellous statements, abortion information, anti-abortion information, advertising of alcoholic beverages, advertising in general, depictions of violence, discussions of suicide, or information on how to build bombs. Throughout the world, there are still advocates trying to ban each of these today. An example would be in the state of Georgia, they tried banning pictures of marijuana. Most efforts to censor the internet in the U.S. include laws passed by Congress focused on pornographic and other sexually explicit materials. The web was first designed for scientific purposes, so the shocking view of pornography came as a surprise for most people. In 3.2.1, they also discuss what was already illegal. So in 1973, Miller v. California established a 3-part guideline for determining whether material is obscene under the law. The criteria are that 1. It depicts sexual acts whose depiction is specifically prohibited by the state or law. 2. It depicts these acts in a patently offensive manner, appealing to prudent interest as judged by a reasonable person using community standards. And 3. It has no serious literary, artistic, social, political, or scientific value. So 3.2.2 is on censorship laws and alternatives. So first we're going to be talking about major internet censorship laws. In 1990, people started using the internet more frequently. People such as religious organizations and others began to campaign for laws to censor the internet. So in 1990, Congress passed the Communication Decency Act, also known as CDA, of 1996. Making it a crime to make available to anyone under 18 any communication that is obscene or indecent. However, it can be difficult to create a law that keeps inappropriate material away from children, but adults could access it. In Butler versus Michigan in 1957, there was a Michigan law that was struck down that made it illegal to sell material that might be damaging for children. The CDA restricted indecent material accessible by children, but a child could access almost anything on the net. So after ruling CDA, the courts made the importance of protecting freedom of speech. Supreme Court ruled unanimously in the American Civil Liberties Union et al. Versus Janet Roe that censorship provisions of the CDA were unconstitutional. And this is also major internet censorship laws continued. So on page 42 of the book, there is figure 3.1 that summarizes principles courts use to help determine if a censorship law is constitutional. When the government is pursuing a legitimate goal that interferes with free speech, they might be the least restrictive as possible. So then Congress tried again with the Child Online Protection Act, COPA, in 1998. This law was more limited than the CDA. COPA made it a federal crime for commercial websites to make available to minors materials harmful to minors as judged by the community. And after 10 years of lawsuits due to the First Amendment, supporters of COPA died in 2009. And this is also major internet censorship laws continued. So then Congress tried again in 2000 when Congress passed the Children's Protection Act, also known as CIPA, to require libraries and schools to use filter software on the internet terminals. The authors of CIPA attempted to avoid the court's objections to the CDA and COPA by using federal government funding powers. And knowing schools rely on those funds, and it found it did not violate the First Amendment. So CIPA requires that schools and libraries that participate in certain federal programs install filtering softwares on all internet terminals to block access to sites with material harmful to minors. So 3.2.2 also talks about video games. So video games have been the main focus of criticism since they began appearing. There has been argued that video games has had more impact on children than watching television or reading a violent story. People would argue that they are too violent and would have them banned. After discussion, a California law banned sale or rental of violent video games to minors. But in 2011, this law was ruled out that it violated the First Amendment. The court found that the impacts were small and differed little from the impact of other media. So 3.2.2 also discusses alternatives to censorship. So there are alternatives to censorship that are available to protect the children on the net. The first one is the development software filters. They can block sites according to various rating systems. They can contain long lists of specific sites to block. Parents can choose categories to filter and their own list of banned sites and review and log their child's activity. Then there's also wireless carriers, which rules are stricter than what government can prohibit. Methods include expelling subscribers who post or email materials banned by the law, or sites policies removing offensive material, and help law enforcement with investigation on child pornography. So in 3.2.3, we are going to be discussing child pornography and sexting. So child pornography includes pictures or videos of actual minors, which are children under 18, engaged in sexual explicit conduct. So production of child pornography is illegal primarily because of its production. The production is considered abuse of the actual children and not the impact of the viewer. So we'll talk about sexting. So what is sexting? So sexting is sending sexually suggestive or explicit text or photos, usually by phone or social media. And child pornography laws were intended to apply to adults who commit a repugnant abuse of the child. And also possession of child pornography is illegal, so friends with children under 18 who has pictures or videos would meet the definition of child pornography. So next on 3.2.4, we are going to be talking about spam. So what's the problem? Let's first talk about spam. So spam is an unsolicited bulk email that now applies to text messages, tweets, and phone calls. This is developed because email is extremely cheap compared to printed direct advertisement. Content can be ordinary commercial advertising, solicitations for funds from nonprofit organizations, pornography, and advertisements for it. Fraudulent get-rich scams and scams selling fake or non-existent products. Spam angers a lot of people of both the content and the way it was sent. And also there are criminal spammers the these people hijacked large numbers of computers by spreading viruses that allow the spammers to send huge amounts of spam from infected machines called zombies. So to continue on with spam, there was cases and free speech issues. There was a problem in 1996 when half of AOL was getting cyber promotions. Now, cyber promotions was an emailing service used to send spam to AOL. AOL filed lawsuits to stop sending unsolicited bulk mailings to its members, and cyber promotions sought an injunction to stop AOL from filtering these emails. AOL's property rights allows it to decide when it accepts on the system. Another example of free speech was in a court case of a former Intel employee called Ken Hamidi. The court case was in his favor, saying that Hamidi's bulk emails was not a trespass because it did not damage Intel's computers or cause economic harm to this company. Now we're going to be talking about reducing the spam problems. So many businesses subscribe to the services that provide lists of spammers to blocked. And all you need to know is spam is cheap. Another way of reducing it is to increase its cost to the sender, include certified email schemes and schemes in which email senders pay a tiny charge to the recipient for each email they send. So now we're going to be talking about anti-spam laws. Anti-spam laws could be significant. An example would be a man sentenced to 9 years in prison. The Supreme Court came up with the Federal Cam-Spam Act, which applies to emails sent to computers and mobile devices. It targets commercial spam and covers labeling of advertising messages and methods generating email lists. Just look at this as a big filter. Many anti-spam organizations opposed the Cam-Spam Act because they preferred seeing spam banned altogether. This law has been helpful in reducing spam problems from legitimate businesses. And last, in 3.2.5, challenging old regulatory structures and special interest, we are going to be talking about the Cpsc. So when people started publishing online newsletters about certain types of investments, they discovered that they were violating a 25-year-old regulation, which was the Committee Futures Trading Commissions, also known as Cpsc. This was a regulation requiring government licenses. License requirements include fees, fingerprinting, background checks, and presenting a list of subscribers on the Cpsc. So publishers that were not registered with the Cpsc could be fined up to $5,000 and jailed up to 5 years. So after looking at this law, a federal judge ruled that the Cpsc regulations were a prior restraint on speech and violated the First Amendment, both for internet publishers and traditional newsletter publishers. So here is the summary of the chapter. So we looked at there are various laws and restrictions of censorship for the web. Many laws were in violation of the First Amendment of free speech. To create alternatives for censorship, they created filters used to block specific websites that would be seen harmful to children. Child pornography is illegal to anyone over the age of 18. Spammers are reducing by using the Federal Cam-Spam Act, and Cpsc ruled out that it violated the First Amendment of free speech. Thank you.